Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the high speed passage with stop. Ready? Start. The appellant stands convicted under Section 302 read with Section 34 of the Indian Penal Code and sentenced to suffer life imprisonment and to other punishments including fine and default sentence under certain other offences. Stop. While granting special leave to appeal, this court, by its order dated 4/7/2017, rejected the prayer for bail. Stop. Another application for bail was therefore preferred, and when the application came up for consideration, it was reported that after having completed 8 years of actual sentence and the appellant being aged about 75 years in accordance with the existing policy of the state government, he was prematurely released in 2019. Stop. This court therefore called upon the state to file an affidavit indicating whether the policy permitted premature release even before completion of actual sentence of 14 years in connection with an offence punishable under Section 302 IPC. Stop. Stanza. The response filed on behalf of the state government indicates that on the occasion of the Independence Day, that is 15th August, 2019, in exercise of powers conferred by Article 161 of the Constitution of India, the Governor of Haryana was pleased to grant special remission to certain categories of prisoners. Stop. Stanza. In Maru Ram versus Union of India and others, the Constitution Bench of this court considered the validity of Section 433A of the Code. Stop. The difference between the powers of communication, oblique commutation, and remission of sentences exercisable under the provisions of the Code or other statutes on one hand, and the constitutional powers under Articles 72 and 161 of the Constitution on the other was dealt with in the majority judgment. Stop. The majority judgment did not approve of the exercise of power under Article 161 of the Constitution by the governor, but emphasized the propriety of making rules by the government for its own guidance. Stop. Stanza. The majority judgment cautioned that mere length of imprisonment may not by itself regenerate goodness in a convict, and stated that the rules of remission may be effective guidelines of a recommendatory nature. Stop. The learned Solicitor General is right that these rules are plainly made under the Prisons Act and not under the constitutional power. Stop. The former fail under the pressure of Section 433A. Stop. But that by no means precludes the states from adopting as working rules the same remission schemes which seem to us to be fairly reasonable. Stop. After all, the government cannot meticulously study each prisoner and the present practices of marks until a more advanced and expertly advised scheme is evolved may work. Stop. Section 433A cannot forbid this method because it is immunized by Article 161. Stop. We strongly suggest that without break, the same rules and schemes of remission be continued as a transmigration of soul into Article 161 as it were, and benefits extended to all who fall within their benign orbit, saved of course in special cases which may require other relevant considerations. Stop. The wide power of executive clemency cannot be bound down even by self-created rules. Stop. Stanza. In Swaran Singh versus State of UP and others, the order passed by the governor under Article 161 of the Constitution granting remission to the person convicted of an offence of murder even before the convict had completed 2 years of actual sentence was set aside by a bench of 3 judges of this court. Stop. Exercise of executive clemency is a matter of discretion and yet subject to certain standards. Stop. It is not a matter of privilege. Stop. It is a matter of performance of official duty. Stop. It is vested in the President or the Governor, as the case may be, not for the benefit of the convict only but for the welfare of the people who may insist on the performance of the duty. Stop. This discretion, therefore, has to be exercised on public considerations alone. Stop. The President and the Governor are the sole judges of the sufficiency of facts and of the appropriateness of granting the pardons and reprieves. Stop. However, this power is an enumerated power in the Constitution, and its limitations, if any, must be found in the Constitution itself. Stop. Therefore, the principle of exclusive cognizance would not apply when and if the decision impugned is in derogation of a constitutional provision. Stop. This is the basic working test to be applied while granting pardons, reprieves, remissions, and commutations. Stop. Granting of a pardon is in no sense an overturning of a judgment of conviction, but rather it is an executive action that mitigates or sets aside the punishment for a crime. Stop. It eliminates the effect of conviction without addressing the defendant's guilt or innocence. Stop. The controlling factor in determining whether the exercise of prerogative power is subject to judicial review is not its source but its subject matter. Stop. It can no longer be said that prerogative power is ipso facto immune from judicial review. Stop. An undue exercise of this power is to be deplored. Stop. Considerations of religion, caste, or political loyalty are irrelevant and fraught with discrimination. Stop. These are prohibited grounds. Stop. The rule of law is the basic for evaluation of all decisions. Stop. The supreme quality of the rule of law is fairness and legal certainty. Stop. The principle of legality occupies a central plan in the rule of law. Stop. Every prerogative has to be subject to the rule of law. Stop. That rule cannot be compromised on the grounds of political expediency. Stop. To go by such considerations would be subversive of the fundamental principles of the rule of law, and it would amount to setting a dangerous precedent. Stop. The rule of law principle compromises comprises a requirement of government according to law. Stop. The ethos of government according to law requires the prerogative to be exercised in a manner which is consistent with the basic principle of fairness and certainty. Stop. Therefore, the power of executive clemency is not only for the benefit of the convict, but while exercising such a power, the president or the governor, as the case may be, has to keep in mind the effect of his decision on the family of the victims, the society as a whole, and the precedent it sets for the future. Stop.